marks are properly arranged.
Yes, yes.
Is
So-
correct.
And on very meticulously, Lordship, everything is written.
And whenever there is something, he'll point out.
Yes,
Yes,
if there
yes.
is any,
Some discrepancy is there, that will be there, that I'll be pointing out that this is what my view is, and this was the court's.
in fact, yesterday I was thinking that whether I should read the judgment or
Yes,
not.
Lordship.
But I did not read it. But I did
Till
not read it because I thought that I should hear it with an open mind
Yes,
completely.
yes. But I like
No,
Lordship,
whatever you want to draw the attention, we will take care.
I take from that, since Lordship I was not reading, but after seeing that it is 80 pages judgment, I thought that I should go through it so that we can develop the argument then. And many things are there, Lordship, which are very much
But
relevant.
don't argue as an appellate.
No, not at all.
appeal
Not
to
at
that.
all. Not at all. Since some points are to be considered in a different perspective, Lordship, that perspective I
No
will
problem.
put before your Lordships. First, the print, Lordship, I'm just going to print.
Explain to him. You have filed your written submissions, I suppose.
Yes, Lordship.
Where do I find that?
16.5. In filing section.
The written argument on behalf of respondent number 16 to 18.
No, Lordship.
Okay.
Yeah, minutes.
एक जगह फाइल करते हैं written submissions. सब एक जगह कर लेते हैं.
वो लास्ट में जो आएंगे
ये मेरे इंटर्न ने किया है कोई काम. वो लोग भी काम कर रहे हैं, बताइए आपके इतना बड़ा रिकॉर्ड. सब लगा हुआ है?
वेरी बल्कि Lordship.
सारे written submissions हैं. सारे written submissions हैं. एक ये क्या है? बाद में आया, लगाइए सब में. एक ये इसको आप खोल नहीं पाएंगे, इसको निकालिए जरा. साथ में आप हमें ये भी बताएंगे इसमें कौन से मिसलिनियस पिटिशंस हैं जो मुझे एडजुडिकेट करना है.
हाँ,
हाँ, that is also important because additional evidence है.
that I have stated, Lordship, in mind. At the end, Lordship will come.
हाँ, ठीक. Wherever it is required to be seen, you just
Yes.
पंकज जी, you are not required. आपके पास काम पेंडिंग है ना? आप कर रहे हैं क्या? आप चले जाइए ना. You are not required. 3:30 बजे किसी को भेजना. संजीव जी, you take stock of this record. इंटरलोकेटरी एप्लीकेशन को छांट के अलग करना है और जो भी एडिशनल एविडेंस है उसका जो रिप्लाई फाइल हुआ है, रिजॉइंडर फाइल हुआ है अलग अलग पार्टीज का, उसको बांध के अलग बंडल करना है. ठीक है, इसको एकदम अलग से करना है ना? सॉरी, ठीक है, रहने दीजिए. साथ में एक साथ सारा रिटर्न आर्गुमेंट एक साथ करते हैं. हाँ, प्लेन दिखिए. हाँ, बताइए.
Plaintiff above named, most respectfully beg to state as follows.
Who are the plaintiffs?
Plaintiffs, Lordship, are the Pauls. They have filed a suit, Lordship, for adjudication of their right title and interest. That has come, Lordship, in page 12 of the plaintiff, Lordship.
And who is the defendant?
Defendant, Lordship, 3-4 sets of defendants are there, Lordship. Basically, 2 sets of defendants which are important to this court. 1, 2, and 3, who are the apparent before Lordship, and 5 to 10, who are the dattas, were recorded in the record of it.
They are also claiming title.
They are now claiming title, Lordship. Earlier, when the suit was filed, strangely enough, Lordship, the Dattas were not made. Since the Pauls claim that they have acquired the right title and interest in a mortgage suit, which they fought against the Dattas. Since when I read
That's
the
fine.
when I read the print, Lordship, I
Yes,
understand.
it's carry on.
Earlier, Lordship, the Dattas were not made party, but subsequently, 5 to 10, they have been added. Lands situated in Mauza, Ranguni, number 2226, within Katras police station, along with other lands, originally belonged to and was in possession of Chandra Mohan Datta. Right from the first line, Lordship, the name of Dattas is there, but they were not made party initially. Son of Sri Such and Such. His nephew, Sambhunath Datta, son of Such and Such, another brother of Chandramohan Datta, in permanent tenure holders' right, each having 2 annas as interest in Mauja, which was later on recorded as such in the cadastral CS survey records of right, finally published in 1925. In 1925, all these Dattas' names were there, and they were having 2 anna each as their tenure holders' right.
तो टोटल 4 आना हो गया ना,
Three persons are
3 persons.
there.
ये है, एक है चंद्रमोहन दत्ता,
हाँ, his nephew
Shambhunath
Datta, such and such, and Shashi Bala Das.
शशि बाला दास. तो टोटल 6 आना.
6 annas. That while thus in
गोराई से
possession,
बुलाएंगे तो बोलिएगा कोर्ट में रहेंगे.
that while thus in possession, Chandra Mohan Datta took a loan by mortgaging his 2 anna as interest in the said Mauja from Murlidhar Paul. Not sure, I'm just pausing a minute for it. Since my entire argument, which is based on this, what is this 2 anna, 4 anna, 6 anna, 16 anna? Out of total is, if 1 rupees is counted, that is 16 annas. We have also heard from our forefathers that we are the Jamindar of this particular village. 16 anna Jamindar. That is, we are the
16 आना रैयत.
हाँ, 16 anna. Not Rayyat, Lordship.
16 आना जमींदार.
Jamindar. Not Rayyat is a different thing. That is what I want to just distinguish before Lordship, because that is the argument which we will be advancing. Now, Lordship, what has happened? This 2 anna interest. First, I am taking this first one, Chandramohan Datta. He has mortgaged his 2 anna interest. That is his tenure holding interest of a Jamindar of 2 anna. That was mortgaged. Because the person who is having the Jamindari right has the power to collect rent from the Rayyats. That was mortgaged. And a degree to that effect was passed in their favor, and they purchased the same. Now what
Right to collect rent was purchased.
Yes. That is my
argument.
submission subject to their argument. Because they will have to show this from the exhibits which they have filed before this court, which is exhibited in this court.
So after, you see, prior to vesting,
Yes, it is prior to vesting.
the property was belonging to zamindars.
Yes,
And they were collecting rent.
rents.
Now you say that it is only the right to collect rent which has vested, which
Yes.
was mortgaged. How? Then their right over the land, along with the right to collect rent, will stand.
That is what I am explaining. What has been mortgaged? As per their print, nowhere specifically they have stated that the 2 anna Jamindari interest as well as the cultivable land of the Jamindar. It is the plaintiff who has to plead their case. Since the cultivable land of the Jamindars, those lands are Belagan, because they are the Jamindars, they cannot give rent to anyone, and neither their rent can be collected. And as such, Lordship, the Khevats have been exhibited. What is a Khevat? Khevat is a Lordship, the tenure holder's right, which shows the right of the tenure holder of a particular village. Khevat only says, Lordship, this is the village and 500 acres, 236 acres, these things are there in the Khevat. Actual particulars, Lordship, are there in the Khatia. This is Khata, this is plot, this is Belagan, this is under such and such Rayyat, this is the type of the land. Sahan, Lordship has read this thing, Shahan, Kheti Wari, Don, Taan 1, Taan 2, Taan 3. These things are special particulars are there. And therefore, Lordship, in the pleading itself, it should have come from them that the 2 ana interest, now subsequently they have taken all 6 ana interest, that I'll come later on. These jamindari interest, along with the cultivable position of the landlord, has also been mortgaged. That I'll develop
Mortgage
later
is
on.
by a document.
That is.
If the mortgage is by a
Yes.
document, we have to see the document.
Yes, mortgage by a document not has been produced, only the decree.
Not
No.
exhibited.
Only the decrees in the mortgage suit has been exhibited. And one title suit of 1941, that has been exhibited. And that was for a different purpose. And a gift deed was there. Some persons who are having the gift deed, they had challenged the rights of the Pauls. They lost in that. That is a particular set of things. That while thus in possession, Chandra Mohan Datta took a loan by mortgaging his 2 ana as interest in the said moja. Very clear terms, Lordship, 2 ana interest in the said moja. From Murlidhar Paul, the predecessor in interest of the plaintiffs and per forma defendant. Haribol Paul, who filed title mortgage suit number 61 of 1928 against Chandra Mohan Datta of the Court of Subject Dhanbad, which was decreed on 23/11/29. The said decree was put into execution in execution case number such and such, that is Exhibit 2. 492 is Exhibit 2 of 1935. And the property was publicly auction sold and purchased by the decree holders on 18/6/1937, was obtained possession through the court on 18/6/1937, and since then remained in physical possession thereof. Now paragraph 3, Lordship. The Sashi Bala died issueless and had 2 ana interest in the moja along with other lands, was inherited by Chandra Mohan Datta. Now Lordship, may kindly see here. Here what they say, the 2 ana interest in the moja along with other lands was inherited by Chandra Mohan Datta. Lordship now can read between the lines. The paragraph 2 again, Lordship will kindly see what I just wanted to point out.
So it could not have gone exclusively to Chandramohan Datta.
नहीं, वो हम नहीं कह रहे, हम ये बताना चाह रहे हैं कि यहाँ ये लिखते हैं कि 2 ana interest in moja, that is zamindari interest,
Yes.
along with other lands was inherited by Chandra Mohan Datta because she died issueless and he is the brother. He inherited the entire thing, the moja as well the interest in the land. And paragraph 2, what has been mortgaged? ये
Interest on the property.
हाँ, ये हुजूर हम बताना चाहते हैं. The next reversioner and after his death was inherited by surviving son Surendra Nath Datta alias Tarni Prasad Datta. That the entire mortgage debt was not satisfied. The degree holder Murlidhar Paul and Haribol Paul filed an execution case number such and such for realizing the rest decretal dues and the entire interest of Sashi Bala Devi inherited by them. That is Kevat number this and the this entire and interest in the Ejmal Kevat number such and such of Moja Raguni was auction sold in part satisfaction to the debt, and the sale certificate dated 18/3/1939 was granted and delivery of possession through court was obtained on 7/4/1939, and the auction purchasers since then continued in possession by exercising diverse act of possession. That thereafter, the execution case number, that is Exhibit 2D, 13840 is Exhibit 2D. 2D. Was filed by them against Surendra Nath Datta and others for realization of the rest of the decretal dues when Arpana Dasya and another daughter-in-laws of Chandra Mohan Datta, and the claim having been allowed, that the decree holders Murlidhar Paul and another filed title suit number 841 under order 21R rule 63 of the CPC of the Court of Subject, which was decreed on 19/9/1942, and thereafter the plaintiff purchasers obtained possession was obtained of them of the said properties through court on 17/3/1943, and thus Muralidhar Paul and Haribol Paul became the owner of the entire interest recorded in the name of Chandra Mohan and Sashibala and remained in khas possession thereof by diverse act of possession. That similarly, Shambhunath Datta has taken a loan by mortgaging his. Now, Lordship, now 2 आना interest goes. Shashibala का 2 आना और Chandra Mohan का 2 आना. That similarly, Shambhunath Datta had taken a loan by mortgaging his 1 आना interest as interest out of 2 आना as share in the moja from the aforesaid Muralidhar Paul and his brother, and on his failure to pay the debts title suit number such and such, that is Exhibit 1 Lordship. Mortgage title suit number 23 of 1930 of the Court of Subject Dhanbad was filed against. Now here also Lordship, now this is the second loan. First was for 2 annas, the entire thing was not satisfied. Then again 2 anna of the Sashibala, which was inherited by the Chandra Mohan Datta, that was also auction sold. Now 4 anna goes. Now this is the third person or the second person, Shambhunath Datta. He also mortgaged 1 anna out of his 2 annas as share in the moja. Here also Lordship, 1 anna share in the moja out of 2 anna. Very well Lordship can gather from this that what was mortgaged? Only share in the interest of Jamindari interest. 2 आना शेयर में से उन्हें 1 आना शेयर मॉर्गेज कर. And his failure to pay the debt entitled mortgage suit number such and such of the Court of Subject Dhanbad was filed against, which was decreed as 1 anna as interest in Khewat number such and such, was auction sold and purchased by decree holders in execution case number 366 of 1931. That is Exhibit 2G, Lordship. And obtained delivery of possession through court on 28/1932. And his rest interest in the aforesaid properties was sold and auction purchased in execution case number 140 of 1940. This is Exhibit 2E, Lordship. For realization of the balance of the mortgage debts by aforesaid degree holders who obtained delivery of possession through court on 3/6/1940. That thus it would appear that the said Muralidhar Paul and Haribol Paul became the exclusive owners in khas possession of the entire 6 anna interest of the moja recorded in the name of the aforesaid Chandra Mohan Datta, Shashibala and Shambhunath Datta. Here also, Lordship, the reading is not complete. How from 5 annas to it became 6 anna? Which they will have to explain. The entire 6 anna as interest of moja recorded in the name of Chandra Mohan Datta, Shashibala and Shambhunath Datta and continuing in possession of the same. Subsequently, there was mutual partition between the brothers and the lands described in Schedule A below, along with the lands fell to the exclusive share of Muralidhar Paul. On his death prior to 1956, the same was inherited by his widow, Ambika Bala Paul, daughter-in-law Latika Bala Paul, and 3 sons, Satyanarayan, Nirmal Kumar, and Ravindra Kumar Paul. On the death of Ambika Bala Paul, her interest was inherited by the surviving heirs aforesaid. That on the vesting of the intermediary interest and under Bihar Land Reforms Act 1950.
This Satyanarayan Paul is not a plaintiff. P1, P2 तो लिखे हैं. Nirmal Kumar Paul and Ravindra Kumar Paul.
Nirmal was there, Lordship.
Yes, and
And
Satyanarayan
Ravindra was
Paul.
there.
He is also there.
No, he is not there.
Yes, he is
Vinay Kumar Paul
in the name of the plaintiffs.
He had 3 and 4.
son
Yes,
of
Is
Sat-
there?
yes.
3 and 4.
3 and 4 are
These
the sons of
represented by.
Satyan. Yes. That on paragraph 9, Lordship. This is important paragraph. That on vesting of the intermediary interest under Bihar Land Reforms Act 1950 on 1/156, the owners filed return as per provisions of the said act. Lordship, there is also not exhibited. I must point it out. What they say, the owners filed return as per provisions. I'll explain what is the provisions.
Returns not exhibited.
No, not. Form K was required to be filed by them before the M roll is granted in their field. There is no form.
M roll is preceded by
Yes,
form K.
form.
If M roll is existing, how do we assume that form K was not there?
Therefore, Lordship, I'll be coming to that. Since entire M roll is now suspicious, we have filed an IA for that purpose also. The owners filed return as per provisions of the Act before the compensation officer. Bagmara constituted under the Act, and after due inquiry, the rent of khas possessed lands were assessed under section 5, 6 and 7 of the Act, and M forms were issued in the names of the plaintiffs and or their predecessors as follows. Now these are the M forms which we have categorically stated in an IA that these M forms are suspicious. Now one more paragraph, Lordship, just before that, again I'll be pointing out. Lordship said that form K is required to be there. Assuming form K is not there, M rule is there. But section 5, 6, 7 proceeding are required to be drawn. The proceeding is drawn. The order is passed. On the basis of those orders, the M form is prepared. The M form is issued. Neither these orders or the proceedings are there on the order. Something has to be there. The basis of M form has to be there. Neither form K is there, nor the proceeding of the BLR Act is there, nor any order under the BLR Act is there. Directly they have exhibited M forms, M rules. And the case M form number is there, year is there, Lordship will find, the Joka number is there, everything is there, but the orders are not there. Correct. That in compensation case number 565 of 1955-56 filed on the basis of return filed by Satyanarayan Paul and his co-sharers, the compensation was fixed, and after final publication of the same by A.C. Dhanbad, Kailash Chandra Datta and others filed objection on 24/9/64, claiming fixation of rent in respect of keyword number 4, that is 4 keywords, that is keyword number 79, 81, 82 and 57, which were not sold, and the order passed, an order dated 19/2/1965. It was held that the entire interest of Chandramohan Sashibala and Shambhu Nag in village Rangunia was sold and rejected their objection. This I'll elaborately detail, Lordship, when I'll coming to this exhibit. That the owners who obviously held that the lands and the tenure holders became statutory occupancy reyes under the estate after vesting, paid rent fixed to the estate, levy paid, and as and when levied chowkidari tax and exercising diverse act of possession. Now, Lordship, this is how they want to deal. That this is how the tenure holders have become the occupancy reyes. What they have done have become statutory occupancy reyes under the state after vesting, on the basis of the M form which they have exhibited. That before and after vesting, some lands were acquired by the government for public purpose, for which compensation was paid to the plaintiff Kailash Chandra Datta, son of Surendra Nath Datta, sometime personally and sometime through collusive transfers filed to disturb peace and disturb possession, for which the proceedings were started, and they all along lost in their efforts. Now what is this? By this they want to say that some lands were acquired by the public for public purpose, for which the compensation was paid to the plaintiff. These are, Lordship, the compensation case which they have brought on record. For the Jamindari interest, Lordship, which was vested in the government, the compensation was liable to be paid to them under section 25 onwards, as per the Bihar Land Reforms Act, Lordship. That in detail I'll come to that, Lordship. That the death of Satyanarayan Paul, his two sons, plaintiff 3 and 4, inherited the interest and are in possession thereof. That Latika Bala Paul has died issueless and on his death, her property has vested in per forma defendant Banibrata Paul, the sole legatee and the executor of her last will, and testament dated 4/3/2005, and the aforesaid persons are in possession of the Schedule A lands, the manner hereinbefore stated. That coming across the advertisement of the defendant number 1 in daily Bengali paper Bratnama dated 20 Vartman dated 29/12/2004 of proposed establishment of Sahara City Homes in Dhanbad, Jharkhand, 10 km west of Dhanbad, on about 100 acres of land, which, though not specifically mentioned, tallies with the plaintiff's land in and around the locality. The plaintiff number 1 gave notices dated 18/2/2005 to his lawyer Shri D.K. Ghoshal, advocate Dhanbad, for the ownership enclosing map of the block, which is the part of their holding described in Schedule A of the plaintiff, and invented negotiation with them only who are the true owners. If the proposed site fell within the said part, and not to deal with the persons having no title or ownership or possession therein, that in spite of the knowledge of the title of the true owners, the plaintiff and the per forma defendant and the defendants are reported to have brought into existence some illegal and void deeds in collusion with the designing persons of the locality without consideration, which fact the plaintiffs have come to recently on or about 3/4/2006. This is for cause of action. The plaintiff has also come to know recently on 7/5/2006 that defendants, as a test of a case, are intending to dump some material on a portion of the land described in Schedule B before and thereafter try to fix boundary pillars after measurement, which they have got no right to do. Hence, the plaintiff is compelled to bring the suit. The per forma defendant number 4, being away, could not join as plaintiff, and as such has been made per forma defendant. That cause of action of the present suit arose on and from 3/4/2006, 7/5/2006, and on other and further dates at Ranguni with the jurisdiction of this court. That the suit is valued at such and such, such and such. For the purpose of the jurisdiction, declaratory fee such and such has been paid. That under the aforesaid premises, the plaintiff may pray for the following reliefs. One relief, Lordship, double A was added subsequently.
First, this one. A is in relation to Schedule A property.
A decree declaring plaintiffs and per forma defendant right title interest and possession over the land described in the Schedule A below, in accordance with the shares indicated therein, with the further declaration that the defendants have acquired no right title and interest therein by virtue of their spurious purchase, and have no right to interfere with the plaintiff's peaceful possession thereof. Now, Lordship, just for a moment. In a prayer also, Lordship, it is very much evident that original defendant 1, 2, 3 had purchased some land from someone. They know about all these things. Knowingly, Lordship, entire Datta family was not implicated at first. This is only, I am repeating time and again, Lordships, this shows the conduct of the plaintiff. When he knows that what is the genesis of the suit, how the case has arisen, why the dispute has cropped up, the person behind the dispute accepting that the Dattas had no right. They were the person.
As of now are party.
Yes.
So it's okay.
Lordship, this is okay now. But the conduct of the plaintiff, knowing very well the genesis of the suit, why the dispute came up, otherwise, Lordship, had the Dattas not sold the land.
It is only certain conducts.
Yes.
Which will non-suit the plaintiffs.
Yes.
But now, once they are party,
Yes.
you just come to this.
Now, A is subsequent. For a decree declaring that any transfer sale deed in respect of the Schedule A property or any portion thereof made or executed by the judgment debtors of execution case number such and such, such and such and such and such, that is Chandra Mohan Datta, son of such and such Datta, Shambhunath Datta, son of late Surya Mohan Datta, and Shachi Bala Dasi, wife of late Shashidhar Datta, or their heirs, successors, and interest is null and void. Since subsequently they were added as party, therefore this relief was again sought for. This was also subsequently amended. That was amended, Lordship, by order.
Since they sought the relief of this nature, that is why they were added as party.
Yes. No. After they got themselves added, Datta got themselves added as party.
And they claimed.
And they claim that how Lordship these persons have tried to.
You see, they are the plaintiffs have challenged the option done through the execution case.
Yes.
Isn't it?
No. The plaintiffs.
You see, the executed by or any portion thereof made or executed by judgment debtors.
Yes.
Okay, judgment debtors of
Yes.
execution case number 6.
What they have done, Lordship, because they are claiming their right title interest by way of these execution cases.
Yes.
Now, since the TAs were added, they made the application for adding them as party, being a necessary party under Order 1 Rule 10. When they were added as party, then Lordship, this prayer was amended. Now what they are saying, since they have acquired the entire interest by the execution case from the Dattas, therefore any transfer now made by the Dattas or their successors will be null and void or having no interest in the property. That is what now their claim is. Earlier, Lordship, all these things were hidden. That is what, Lordship, this is the conduct. Now I will say that this will non-suit to the plaintiffs, because subsequently it was added. They were bound to add this, since now Datta came forward. Now, Lordship, our WS. And the schedule, Lordship, entire schedule has been given thereafter. A decree for confirming plaintiff's performer defendant's possession of the Schedule B land and a permanent injunction restraining the principal defendants, their main agents, contractors, etc. from going over the portion of the Schedule B land, making any erection, construction or dumping any material in the such and such cost of the suit. Thereafter, Schedule A.
And one more thing.
Lordship.
With respect to Schedule A property, there is a reference of will also. That will has been prohibited.
No, Lordship. The will.
Para 13.
Para 13 of the.
Claimed.
Just वो हमारा claim.
What is this will about?
Lordship, I'm just. The property of the Pauls, Lordship. There is the property between the Pauls. One of the Paul died issueless, and she has executed some will, and the other sharers got the property by that. I am not concerned with this, Lordship.
But it is relating to Schedule A.
Yes, Lordship.
And
the aforesaid persons, because when they are claiming the land through the execution case, some person died issueless and she has given the will.
That is irrelevant.
For us, Lordship, not relevant. Now, the WS on behalf of the defendant number 3. Only defendant number 3, Lordship, has filed their WS.
There is one preliminary objection also.
Sorry, Lordship.
Preliminary objection is also there.
That is WS. ऊपर में जो लिखा हुआ
हाँ वो ऊपर है.
हाँ WS का this is the how they have prepared the WS. 3 defendants were there, Lordship, earlier. Main defendants contesting. Sahara India Commercial. Thereafter, the regional manager of the Sahara India Commercial Corporation. And third is Messrs. Karmyogi Gray Nirman Swavlambi Sahakari Samiti.
This is Samiti.
This is also Sahara का ही part.
ऐसे part तो नहीं हो सकता ना. Sahara is a company. सहारा का पार्ट किसको बोलेंगे इसको?
नहीं सहारा इनको जमीन दिया. Sahara had sold this the land.
Sahara had transferred. How does Sahara come into picture? These properties were sold to Sahara, and then Sahara sold to defendant number 3. सहारा कैसे पिक्चर
हम इस WS में रखा है. The plaintiff discloses no cause of action in favor of the plaintiff and against the answering defendant, such as the same deserves to be rejected at very outset. The present suit has been filed solely with the view to harass the answering defendant and is not based on true and correct facts, and as such, same deserves to be rejected at very outset. The present suit as bad for non-joinder and misjoinder of parties. As regards, this was Lordship filed in 2006, December 2006. This was our main issue at that time. Misjoinder and non-joinder of parties. As regards misjoinder of parties, it bears mentioning that defendant number 1, 2 have no concern whatsoever with the suit property, and as such their names are liable to be deleted from the area of the parties. As for the misjoinder is concerned, the lacuna is fatal because some portions of the property detailed in item 1 to 5 of Schedule A of the print has been purchased by the answering defendant from Dhirendra Nath Datta, Mr. Krishnendu Datta and Swarup Kumar Datta and other members of Datta family, whose predecessor, namely Chandra Mohan Datta etc., were Khatyani Rayar, and undisputedly Dattas have been in possession of the property detailed in Schedule A of the print before they delivered possession of the various portions thereof to answering defendant, as well as the other purchasers, but some portions thereof to the answering defendant, as well as the other purchasers, but some portions thereof are still in possession of the Dattas. As declaration of title of entire property detailed in Schedule A of the print has been sought, so the Dattas, that is the successors of the Khatyani Rayas, ought to have been made parties in the suit. In the present plaintiffs entitled suit number 26/2003, which relates to the land of Khata number 65 of Moja Ranguni, and the land under the same Khata number 65 is a part of the suit property in this suit. Non-implement of the Dattas is deliberate and modified because the plaintiffs know that Dattas and their transferees have been in possession of the entire property detailed in Schedule A of the print. Since CS record of rights, the Dattas have unimpeachable documentary evidence to establish that possession as well as their title, so the present suit cannot proceed unless Dattas are implicated as parties. The suit is hopelessly barred by limitation as Khatyani Rayas, their successors, that is Dattas, the vendor of the answering defendants, as well as the answering defendant and other purchaser from Dattas, have been in possession of the property detailed in Schedule A of the print for over 100 years and exercised variable acts of possession like constructing house, structures of various nature thereon, and residing therein with their families. As a matter of fact, there are more than 26 transferees who had purchased the land in the property detailed in Schedule A of the print from Dattas between 1964 to 2005, and those purchasers have got their names mutated in revenue records, constructed houses thereon, and are living therein with their families. Even the answering defendant purchased property detailed in Schedule A of the print and has possessed the same as the owner thereof. The fact that Dattas and their successors have been in possession of the property detailed in Schedule A of the print, as has been established in various judicial and quasi-judicial proceedings, referred to hereinafter, including in an order passed in an application under Order 39, Rule 1 and 2 of the CPC, entitled Suit number 26 of 2003. So the interest, if any, that the predecessors of the plaintiff have got extinguished by a flux of time, and at present the answering defendant and his predecessors have been in actual physical possession as owner much prior to the preparation of the CS record of right in early 1920s. Thus, the suit is hopelessly barred by limitation. The suit is barred by Section 34 of this 34 of the Specific Relief Act, as the plaintiff have never been in possession of the suit and as such are not entitled to relief of the declaration of title. The suit is grossly undervalued, which valuation is patent. The plaintiff are guilty of suppressio veris and suggestive falsi. Therefore, the plaintiff deserves to be dismissed. Plaintiff suit is deserved to be dismissed. The present suit is heard by the provision of section 10 of the Code of Civil Procedure, inasmuch as the matter at issue in the present suit is directly and substantially in issue in the previously instituted suit filed by the present plaintiffs against Dhirennath Datta and others. The previously instituted suit bearing title suit number 26 of 2003 is pending in the Court of Munsif Dhanabar. A certified copy of the plaintiff written statement order passed in an application under the 39 Rule 1 and 2 of the Code of Civil Procedure is and issues settled therein are being filed herein. In this view of the matter, the present suit deserves to be stayed in the light of the provisions contained in section 10 of the Code of Civil Procedure.
Was it stayed? सूट स्टे का नहीं हुआ था ना?
नहीं, ये सूट इसको स्टे करने का
This was ultimately compromised.
Sorry, compromise.
Was compromised and disposed.
for a particular some piece of land. On merits, that the content in para 1 of the plaint call for no reply being matter of inquiry. That the contents of para 2 of the plaint, so far as they are born out of the records, are not denied. However, it is submitted that the plaintiffs be put to strict proof of the averment contained in para under reply, specifically denied that the predecessors in interest of the answering defendant were ever dispossessed from any portion of the property detailed in Schedule A of the plaint, either pursuant to any order of the court or otherwise. The defendant as well as their predecessors in interest till date, from times immemorial, are in open possession of the land in question, to the knowledge of the plaintiff, and are enjoying the said property as owners thereof. The plaintiff have no concern whatsoever with and or over the said property. The contents in para 3 of the plaint call for no reply. However, it is submitted that the plaintiff be put to strict proof for the averment contained in para under reply. That the contents of para 4 of the plaint, so far as they are born out of the records, are not denied. However, it is submitted that the plaintiffs be put to strict proof of the averment contained in para under reply. It is specifically denied that pursuant to the execution case number 144 of 1938, the possession of the land detailed in para under reply was handed over to the decree holders as referred to in this para through court on 7/4/1939 as alleged or any other date for that matter. It is further denied that the auction purchaser as referred to in para under reply continued in possession of the land referred to above by exercising diverse act of possession. The fact of the matter is that the predecessors in interest of the answering defendant were never dispossessed from the land in question, and they are continued to remain in possession and enjoyed the same as owners thereof openly and to the knowledge of the plaintiff, and one and sundry. Even the answering defendant is in possession of this land and is enjoying the same as owner thereof.
Do you want to say that pursuant to the auction in the execution case, etc., it was just paper document?
We want to say that whatever happened at the time of execution, the proprietary interest was given to them, and no act of possession was exercised by them, as it was not at all given to them. The act of possession over the agricultural land or any portion of the land was never exercised by them.
How the auction is? You see, there are dues adjudicated,
Yes,
and to realize that dues, the property
and
is auctioned.
that is ex parte degrees, Lordship. I'll come to
Whatever,
that. Yes,
Degree
degree is there.
ex
Degree.
parte or
Yes,
contested.
That
it
will.
is. So therefore, do you want to say that there was auction, right, for realization of dues, auction of immovable properties?
Auction of the proprietary interest, that has to be considered, Lordship, what I am submitting. Immovable property, nowadays, Lordship, the auction of immovable properties is there.
The auction is for realization of dues.
Dues, yes.
Right? If there are certain dues to be realized, any property can be put for auction sale,
Yes.
correct?
Yes.
Then under such circumstances, by virtue of sale of that property, what will be the court get out of that? The court will get money out of that,
Yes.
and sale will be confirmed and possession will be done.
Yes.
This is how it is.
This is how nowadays, Lordship. Now in this case,
It is not, no, it is very important because you
Yes,
are
yes.
saying that it is only the interest.
Yes.
Maybe only the interest was mortgaged.
Yes.
But when it comes to realization of dues, what is sold is not the interest in the
That
mortgage
is what I am
property.
submitting.
What is sold,
Something, Lordship, which I mortgage.
it is
The
one.
option cannot be more than my mortgage. If I have
It's
mortgaged,
not like this, Mr. Vishal, please appreciate that. You mortgage a property, you say that only a particular interest in the property, maybe right to realize rent, I mortgage, right? Once that right to realize rent is mortgaged, and then there are certain dues to be realized arising out of such mortgage, suit will be filed for recovery of the amount, right? And that amount is to be recovered through a process of court by selling the property. You will not say that the sale of the property will be to the extent only to the mortgage, what was mortgaged. The sale of the property, like suppose there is, let us take a present day example.
Yes.
A property is mortgaged, your house is mortgaged, my house is mortgaged, not your house. My house is mortgaged.
a flat is mortgaged.
A flat is mortgaged, I take loan. Upon sale of that property, upon being defaulter, that is, a suit is filed for the recovery of the dues. The amount is not satisfied, then they will take possession of my car also and sell it, right? So what is being sold? What is being sold for the purposes of realization of the dues is right, title and interest over the property. You cannot say that what is being sold is only on the interest of the
I
property.
differ on this, Lordship. If I mortgage a flat in the bank if gives me loan of 1 crore on that flat, and after auctioning it, he only recovers 80 lakhs. For the rest 20 lakhs, Lordship, the bank will be liable. Why he has mortgaged the property which does not have the value of 1 crore.
No.
Other property like my car or any movable or immovable property cannot be auctioned. That is my submission.
No, this is against law. It doesn't work like that. It doesn't work like that. Whenever there is a dues out of a deed, then it is the money value which is to be recovered. And at the time of recovery, what is being sold, if the property is put for auction, it is the property which is sold.
Yes, yes.
And not the interest on the property. You cannot say that only the interest on the property is being sold. It is the money value which is being recovered.
Lordship, we kindly appreciate.
Auction
We have to take ourselves at that time. At that time, Lordship, the Jamindari interest was auction sold in many cases. Not only this, Lordship. Only if we are not able to pay the cess to the government, the main government at that time, the Britishers, if we are not able to give cess, the entire Jamindari interest was sold to some other person who can realize proper rent and give cess to the Britishers. That was the
auction was for on account of default, or it was for realization of dues.
It was, Lordship, since the mortgage dues were not satisfied.
So it was
default.
for realization of dues.
Yes, as per the mortgage.
So therefore, if it is for realization of dues, then the transaction between the arrangement between the parties will be terminated and the dues will be realized. Merely because the right is being transferred to somebody else for realization of rent, that realization of rent will be in future only. What will happen for the entire dues for 10 years which was not realized and paid?
Here in this case, Lordship, the entire dues was satisfied. By 2 anna, 4 anna, 6 anna, whatever there was, that in execution cases, those were satisfied. As per my submission, by my right to recover rent, by that only it was satisfied. Therefore, there is no mention of the lands which are to be given in possession to the person who has taken the agricultural land or the land in actual possession.
We'll see the documents
Yes.
for that purpose. But this is what your contention is.
Yes. And they have to
So
furthermore,
your
Lordship,
core contention is that at the time of auction, the right title interest over the property was not sold,
yes,
right?
on the position of the land, which were in cultivable position or the direct position of the landlords, ex-landlords, Dattas. And this is fortified, Lordship. My argument is fortified with the suspicious M rolls. The M roll which they have exhibited as Exhibit 10 series, only 3 M rolls were said to be certified copies, 2 photocopies were there. Not to talk about the proceeding under 567 of the BR Act, not to talk about the K forms, nothing was there. And
In
therefore,
the
Lordship,
returns or
Yes.
in the enroll, what was your status?
subsequently, Lordship, in 1981 and 82, we also filed an application for assessment of rent and giving a rent receipt to us. That was accepted. And I'll give the Lordship's judgment on that point. They will come that in 2008 or 2010, one miscellaneous case was filed after 20 years. Although the Pauls were party in that rent assessment case
इस
of
केस में
19.
हमको डिसाइड भी किया है।
हाँ,
हमको तो क्या डिसाइड किया?
हुजूर डिसाइड ये किए हैं कि 20
कहाँ
साल
है
के बाद
judgment?
नहीं, हुजूर का हम सब जजमेंट देंगे, लास्ट सब देंगे। लॉर्डशिप जजमेंट इज देयर कि आफ्टर 20 years जवाबंदी which was created by the order of the circle officer, the other person contested, they did not file an appeal in accordance with the act, Tenants Holding Act, Lordship, and after 20 years a miscellaneous case was filed with the deputy commissioner, and that was decided in their favor, cancelling my jababandi. And that jababandi which was opened in the 1982-83 had cancelled their jababandi, which was saying to be fictitious.
That order has become final.
Since Lordship, no one appealed, as they had not appealed. After 20 years, when application was filed, and since Lordship is required to adjudicate this point also, whether the order of the deputy commissioner can sit over the suit, which is entire suit is now being decided only on that order.
You see, if we are talking about the title over the property, then it is not a case that after vesting of zamindari, whether any right of the zamindar qua that property was existing, not existing. Everything will boil down. That is what is the consequence of auction.
Consequences
Of auction.
yes.
Everything
Yes.
will boil down to that.
To that Lordship, and
If
subsequently.
the auction is held to have transferred a particular right in a particular manner,
Yes.
irrespective of M-roll, the property will be
That
there
is,
of
that is
zamindars.
the core question, Lordship, and subsequently the act over the said auction. Now, if the M rolls are being produced by them, I accept the M rolls are being produced. What are the things has to be seen by the court. Since the M rolls, 3 only certified copies, that too subsequently in our IA it has been said by the circle officer that these M rolls are not in our record. 2 copies were there, they were not certified copies, cannot be accepted in evidence. And thirdly, no proceeding under section 5, 6 and 7 of the BR Act. Something has to be there. K form is not there. How much liberty can be given to them? And
If
when
these things are not there,
yes,
then what is the consequence? The
Consequence-
property will rest in the state.
no, what I am submitting.
What is your locus?
What I am coming, my locus is that, again I'll come to my argument. My locus is that since the Dattas have sold the properties to us, and Datta had a right over the agriculture and other immovable lands, which they were in possession as Khatyani Rayats, as Khatyani tenure holders, and the land in their possession as Kaimi or Jirat, whatever it is.
Do you want to say that at the time of mortgage, the property, the tenancy of Dattas was existing?
Yes. Since
So let's take it this
Yes.
way. Your case would be, as I see it, that if a property is mortgaged with tenancy of Dattas,
yes,
then under such circumstances, what is mortgaged is property with a tenant. Then under such circumstances, upon vesting, the right of tenant will still survive irrespective of mortgage and irrespective of auction status.
Yes, that is my submission. Since the tenure holder holding right, 2 annas, specific words are there. 2 annas along with the other immovable, cultivable properties of the Mauja.
Where is the case of the Dattas as to what was their status?
Yes, Lordship, we'll come to that in their
You read it.
WS also. First, we'll finish this, Lordship. Para 13, Lordship, we are reading. That the contents of para 5 of the print, so far as they are born out of the records, are not denied. However, it is submitted that the plaintiffs be put to a strict proof of the averment contained in para under reply. It is specifically denied that pursuant to title suit number 8 of 1941 or execution case number 130 of 1940, the possession of the land was handed over to degree holders as referred to in the para to the court on 17/3/1943 as alleged, or on any other date for that matter. It is further denied that the land referred to above by exercising diverse not of possession. The fact of the matter is that the predecessors in interest of the defendant were never dispossessed from the land in question, and they continued to retain their possession and enjoyed the same as the owners thereof openly to the knowledge of the plaintiff. This is what Lordship was saying. And plaintiff, one and sundry. The answering defendant is in possession of this land and is enjoying the same as owner there. The contents of para 6 of the plaintiff, so far as they are born out of the records, are not denied. However, it is submitted that the plaintiffs to be put to strict proof for the averment made in para under reply. It is specifically denied that neither pursuant to title suit number 23 of 1930 and in execution case number 366 of 1931, the possession of the land described in para under reply was handed over to degree holders as referred to in this para through court on 28/1932 as alleged, or any other date for that matter, nor in execution case number 140 of 1940 on 3/4/1942 as alleged, or any other date for that matter. It is further denied that the auction purchasers as referred to in para under reply continued to be in possession of the land referred to in above by exercising diverse act of possession. The fact of the matter is that the predecessors in interest of the answering defendant were never dispossessed from the land in question, and they continue to remain in possession thereof and enjoying the same as owners thereof openly and to the knowledge of the plaintiff and one and the sundry, and even the answering defendant is in possession of the land and is enjoying the same as owner thereof. The contents of para 7 of the plaintiff are emphatically denied. Being wrong and incorrect, it is specifically denied that Mr. Murlidhar Paul and Haribul Paul became the exclusive owners in possession of the entire interest of Chand Mohan Datta and others, or any part thereof as alleged. It is further denied that the said Murlidhar Paul and Haribul Paul continued to possess the said land. The fact of the matter is that the predecessors in interest of the defendants were never dispossessed from the land in question, and they continued to remain in possession and enjoying the same as the owners thereof openly and to the knowledge of the plaintiff and one and sundry, and even the answering defendant is in possession of this land and is enjoying the same as owner thereof. The contents of para 8 of the plaintiff is emphatically denied. Being wrong and incorrect, it is submitted that the plaintiffs be strict proof of the averment made in contained submissions. It is denied that the partition ever took place between the predecessors and interest of the plaintiffs. The averment made in para under reply qua partition, acquisition of exclusive title and inheritance thereof are nothing but a cook and bull story, which has been concocted and fabricated by the plaintiffs with the sole purpose to grab the land and not belong to them. In fact, the predecessor in interest of the defendants have been in continuous possession of the entire land as detailed in Schedule A of the plaintiff to the knowledge of the plaintiff and the predecessors in interest, and have been enjoying the entire said land from the times immemorial till date continuously and without interruption whatsoever as owners in possession thereof. The contents of para 9-10 of the appellant are emphatically denied, being wrong and incorrect by misrepresenting the true and correct facts. The plaintiff and the predecessors in interest, in collusion with the then revenue staff, got incorporated their names in N forms as detailed in para 9 of the plaintiff. This in the WS itself, Lordship, we have made doubt about all this, and I'll show how. Detailed paragraph 9 of the plaintiff. The fact, however, remained that despite the incorporation of the names as aforesaid, the plaintiffs had no connection or relation of any nature whatsoever with any portion of land as detailed in Schedule A of the plaintiff. On attaining the knowledge of the plaintiff, that the plaintiffs and the predecessors have fraudulently, by misrepresentation and in collusion with the revenue staff, got their names incorporated, despite of the fact that they were neither were in possession nor had any concern whatsoever with the land detailed in Schedule A of the plaintiff. The defendants or the predecessors filed application for fixation of rent.
Just a moment. In Form N, is it the name of Zamindar it is mentioned, or it is the name of the
Rayats.
The Rayats.
Now what's, I'll just explain.
Yes, just
as per section 7.
In Form N, their name has been entered as Rayat,
As Rayat.
not as Zamindar.
No. M form is for Rayats.
For Rayats. So you want to say that they never acquired the status of Rayat.
Yes.
Continue.
Because the M form is fictitious, and I'll also show
Not
how
because M form is fictitious, that is a separate thing altogether. Even if it is included, you say that they never acquired the status of Rayat.
No. If the M form is proper and correct, then they acquire the
It is one
status
thing
of
to
Rayat.
say that M form is a forged document.
Yes.
It is another thing to
I
say
cannot
that
say.
entry made in M form
Yes.
is incorrect.
Yes.
What do you want to say?
Then I want to say, if the entries are taken as what they are producing, if the names in the M forms are there and properly done, then they acquire the status of Rayat. Anyone. Even Lordship, I'll give my example. Our forefathers were Jamindars, and Form K was submitted. By Form K, I'll give the detail. What is the Form K? We have to give now these lands are in my cultivable possession, is being done by my servants or by my agents. These details have to be given in Form K, and thereafter the proceeding under 4, 5, 6 and 7 is to be initiated.
That's right.
The order is to be passed, and then our status changes from
As per their case, Form N was filed by whom?
for
N.
they have to file.
No, the Zamindars.
Jamindar will have to file
That is false.
Form K.
That is
Yes.
false.
False.
False,
False.
right? They file Form K
If they file.
if they file. Form K
Assuming
is
they
not
file.
there. Let us assume that they
Yes.
file. Which is followed by issuance of Form M.
Which is followed by rent assessment proceeding under 5, 6 and 7.
And then
Finally, the order is passed under those proceedings, and finally the M form is issued confirming their status as Rayats of such and such land.
So, in M form, who were shown as the Rayats? The plaintiffs?
Yes. As per them, therefore they have produced that.
Now, the plaintiffs were initially the Zamindars,
Yes.
but by virtue of M form, the state became the owner of the land and they acquired the status of Rayats.
Rayats for a particular, if let's assume a village has 100 acres of land. The entire land is not the cultivable land of the Jamindar.
That's right.
Several
There
Rayats
could
are
be many Rayats.
yes, many Rayats. But some special lands which are under the direct cultivation of the landlords. For that lordship, Form K is required to be submitted by the landlord themselves.
That's
भाई
right.
ये हमारा जमीन है
रैयत
जो कि
है।
हमारे
जो
कल्टीवेशन में है,
हमारे कल्टीवेशन में
हमारे
है,
नाम
उनके
से हम फॉर्म
cultivation
इशू
में-
करके हमको रैयत बनाया जाए और उस पर लगान निर्धारित करके एक रेंट फिक्स किया जाए ताकि वो रेंट हम सरकार को दे सकें. That is what the purpose of M form and the Form K and proceeding 5, 6 and 7.
भाई, जमींदारी उन्मूलन का एक ही
Yes.
जमींदार को खत्म कर
खत्म
देना
करिए
है.
सरकार जी.
Zamindar acquires the status of Rayyat so far as his properties are concerned,
Yes.
and those who are tenants,
Yes.
they will become the Rayyat of the
अब
state.
सरकार
बस
हम भी रैयत हो गए वो भी रैयत. ठीक, now lordship.
ठीक है, इसको पढ़िए तो।
हाँ, पैराग्राफ 17. That the contents of para 9 and 10 of the print are emphatically denied, being wrong and incorrect. By misrepresenting the true and correct fact, the plaintiff and petitioner interest in collusion with the rent revenue staff got incorporated their names in M forms as detailed in para 9 of the print. The fact, however, remained that despite the incorporation of the names aforesaid, the plaintiff had no connection or relation with any nature whatsoever or any portion of the land as detailed in Schedule A of the print. Now, Lordship, what I want to say here, even if, assuming that the M forms are correct, they never exercised their right as the reyers over the said land because they never came in position. The Dattas were all along in position. The fact, however, remained that despite the incorporation of names aforesaid, the plaintiff had no connection or relation of any nature whatsoever or any portion of the land as detailed in Schedule A of the print. On attaining the knowledge that the plaintiffs and the predecessors had fraudulently, by misrepresentation and in collusion with the revenue staff, got their names incorporated despite the fact that neither were in possession nor they had any concern whatsoever with the land detailed in Schedule A of the print, that the defendants and their predecessors filed application for fixation of rent in respect of the land detailed in Schedule A of the print under Section 5, 6 and 7 of the Bihar Land Reforms Act 1950. These applications were registered at, now this is very important, applications were registered as rent fixation case number 1 bracket 38283 2 bracket 382 81 82. In these proceedings, after hearing both the parties, it was found that the defendant and their predecessors have been coming in uninterrupted continuous possession of the entire land detailed in the Schedule A of the print. This we have exhibited. The present plaintiffs, as in made in para 9.
I have one more question. The
Yes.
plaintiffs, after this Form M, did they get their rent fixed? Were they paying rent to the state?
ये जो फॉर्म M होता है, ये 5, 6, 7 का जो प्रोसीडिंग होता है, वो रेंट फिक्स करके M फॉर्म इशू होता है।
अच्छा, करने के बाद
हाँ,
M form issue।
क्योंकि उसमें सब डिटेल रहेगा।
उन्होंने
ये जमीन में
वगैरह
आपको
कुछ पेमेंट किया?
हाँ,
Did they
रेंट
make-
रिसिप्ट है।
उनका रेंट
हाँ,
रिसिप्ट।
that I will also come. अगर ये M फॉर्म भी सही नहीं है तो रेंट रिसिप्ट भी गलत है।
We will see that. लेकिन रेंट रिसिप्ट इनके
हाँ,
पास है।
हाँ, that has been explained.
The present plaintiff, पढ़िए,
हाँ।
पढ़िए।
Lordship, in these proceedings, hearing both the parties, that was find the defendant and the predecessor in interest and coming into position, the present plaintiffs is made in para 9 of the print has no basis or any entry in the register with regard to the rent roll having been prepared. It was also held that the plaintiffs and the predecessors were at no point of time in possession of this land. As per these orders, the rent was directed to be fixed in the names of the defendants and their predecessors in interest, pursuant to which the fresh M forms were prepared and the thokas were also created in their names. The order passed by the competent authority in the presence of the plaintiff. This is very important.
किसको अटेंड? ये कलर कर।
In the presence of the plaintiffs, they were party to this proceeding. The orders passed by the competent authority in the presence of the plaintiffs and the predecessors in interest have attained finality in view of the fact that those orders were never challenged by the plaintiffs and their predecessors in interest before any appellate tribunal or any other authority court. Now I'll pause here for a moment.
ये जो नया M form issue हुआ, what was it? An act of cancellation of earlier M form and fresh M form was issued?
What happened, Lordship, since we were in position, we gave an application for fixation of rent and 5, 6 and 7. While considering everything, since they were also made party, they were called upon and everything was decided in presence of them. And in that, Lordship, perhaps I have not entirely read that exhibit, perhaps their order, earlier order, was said to be non-est in the eye of law because no proceeding, no number, nothing is there. And therefore, the fresh M forms after fixation of rent was issued in our court. That I'll subject to correction, Lordship, since I have to come to that. अभी पूरा हम पढ़े नहीं उसको.
आगे पढ़िए.
हाँ. It shall not be out of place to mention. हाँ, एक मिनट हम पॉज किए थे यहाँ पे. ये जो हम यहाँ लिखते हैं, it was never challenged before any appellate, revisional or any authority in the court. This WS lordship was filed in 2006. At that time, there was nothing. A miscellaneous case was filed by them sometime in the year 2006 or 8, wherein lordship the order was not being passed. They came to the High Court, some persons came to the High Court, some Paul, and said that one miscellaneous proceeding of 2005 or 6 is pending before the competent court. It is required to be disposed of. The Honorable High Court passed an order for disposing of that matter within 4 or 6 months, something like that. And thereafter, lordship, in a miscellaneous case, after 20 years, since 82-83, lordship, the rent fixation case was there. In 2005, a miscellaneous case was filed by some of the Pauls. The entire proceeding of 81-82 was cancelled.
What happened thereafter?
Thereafter, lordship, nothing happened because the suit was pending. The suit was going on.
That order was not challenged.
Not challenged because that has been exhibited here. Since lordship, it is civil court of competent jurisdiction, has the entire power to say whether the proceeding which was during pendency of the suit has come up, whether it is proper, legal or not. And I was referring to a lordship judgment that I also gave. Since lordship has taken note of that after 20 years without an application of limitation.
In one judgment I have passed that the person will not acquire the status of rayyan unless he is in physical possession of it.
Yes.
Where is that judgment?
Sublime something.
आप खोज लिए हैं
सब yes.
क्योंकि हमको याद आ रहा है
हाँ।
इस केस में हम ऐसा जजमेंट किए हैं.
Yes. और ये तो सबसे बढ़िया जजमेंट जो हुजूर को दे रहे हैं कि 20 साल के बाद जो लेके आए हैं. Since the suit was pending, therefore there
मेरा
was no
जजमेंट मेरे
occasion
पास
for us.
बढ़िया बोल के तो कुछ हासिल नहीं होने वाला है.
नहीं, lordship,
इसीलिए
because
कोई फायदा नहीं.
that is one of the landmark judgment lordship which I think I was also appearing in that case. The lordship has passed that, rightly considering that after 20 years, everything given a go by the revenue authorities, whatever they like they do, that order could not have been passed.
Let's आगे.
Yes. The orders passed by the competent authority in the presence of the plaintiff and the presence of patent finality in view of the fact the orders never challenged by the plaintiffs and the predecessors in interest before any appellate revisional or any authority of the court. It shall not be out of place to mention here that the defendants have since been paying rent to the state government. The orders passed by the competent authority in the presence of the plaintiff, it shall also be pertinent to mention here that no point of time the rent was ever received by the state government from the plaintiffs and the predecessor in interest pursuant to the issuance of M forms in the year 1962-63. In light of the fact, the circumstances mentioned here and above, it is apparent that the plaintiffs are guilty of sub ratio, very and suggestive falsity, and as such they score alone. At the very initial stage, the suit deserves to be dismissed. The contents in para 11 of the plaint are vague, of the extreme, and as such no reply to the same is being offered at this stage. However, the answering defendant reserves its right to file appropriate reply as and when the plaintiff clear the ambiguity in the para under reply.
These are essentially the cause of action.
Lordship.
Your entire case rests there itself. Schedule A and Schedule B. The entire written statement is in connection with Schedule A. I do not find mention of Schedule B anywhere. What is Schedule B property? Schedule B is a distinct property. It is not a part of Schedule A property. Is there anything mentioned about Schedule B property?
Lordship, let me find it from the plaintiffs.
Portion of Schedule A land.
Schedule
Yes,
A
it is
portion
Para
of
Yes.
Schedule
16.
Schedule
Para
16
Big
of
portion
Page-
of Schedule
Okay.
A land. नहीं, Schedule से
Schedule page 19.
Big portion of Schedule A land.
Page 19 जो देखा जाए of the plaint. Page 19 of the plaint. Being portion of Schedule A lands of the following plots between such and such.
Statement is there in para 16. Some materials were being dumped there that we throw there.
And the call of action notes which they have come, that some materials are being dumped. For that injunction, probably they have sought. Para 16.
Okay. That's fine. Then Who else filed the written statement? What is the written statement of Datta's?
Now, Datta's lordship had filed an application under Order 1, Rule 10, which was treated as WS lordship.
It was treated as WS.
Yes. Perhaps on their application,
That's right, it's okay. Whatever they had to say, they must have said in it.
yes.
This order 1 rule 10 was allowed.
Yes.
What is their case?
Lordship got that.
Yes.
The plaintiffs have filed a present suit for declaration of the plaintiff's right, title, and interest in Schedule A of the land. And the defendants of the suit, who are the purchasers from the present petitioners, have no right, title, and interest in it. That from the plain reading of the print, it will transpire that the plaintiffs have claimed that the Schedule A land situated in Moja, Ranguni, originally belonged to Chandra Mohan Datta, Shambhunath Datta, and Sashi Bala Datta, who were the predecessors of interest of present petitioners. But later on,
नहीं, ये कुछ और ही है. Petition under no ये injunction वाला है. Sorry.
Order 1, Rule 10,
हाँ,
ऊपर पे लिखा हुआ है.
Order should cause injunction वाला petition. ये injunction वाले petitions हैं. नहीं, इसमें नहीं. इनका WS दिखा तो निकाल दो WS. Check करते हैं. आप जरा हेल्प कर सकते
हाई कोर्ट
हैं थोड़ा सा.
बट हम कॉपी पास कर देते हैं.
नहीं ऐसे नहीं.
एक बार
आप रिकॉर्ड से देखो.
तुरंत मिल जाए.
ऐसे ना बहुत मुश्किल है. और क्या रिकॉर्ड है हमारे पास? Exhibits. ये जितना भी ये लगा हुआ है ना, सब स्टेप भी करते जाइए, नहीं तो गुम हो जाएगा.
It must be in the other file, Your Lordship, where
क्योंकि बाद में फाइल हुआ होगा
other
ना.
interlocutory applications were the
देखिए ना, मिसलेनियस पिटीशंस
वो
किसी
उनको
में
समझ में नहीं आया होगा जो लोअर कोर्ट
तो
रिकॉर्ड भेजा
गलत लगा
है
दी.
because it is nomenclatured as order 1 rule 10 therefore
There.
उसको अलग कर दूंगा. लेकिन भेजते तो होंगे ही मेरे ख्याल से.
तो गलत लगा दिया.
ये
39 बार लगा दिया. इसमें नहीं.
आप लोगों के पास है क्या?
हाँ मिल जाए.
दीजिए ना, एक कॉपी दे दो.
आप बढ़ा देते हैं कॉपी पास.
इसमें तो कोई डिस्प्यूट नहीं है ना.
नहीं ये इसमें
हम दे देते हैं. आप बढ़ा देते हैं.
नहीं
that Your Lordship we take it on record itself.
या आप दे रहे हैं
नहीं नहीं इधर.
तो हम तो रख लेंगे, फिर आपको वापस नहीं देंगे.
ठीक है.
ऐसे
बस आप इनसे जरूर
अब इसको ले.
हाँ, आप ये वापस कर दीजिए. हमको ऐसा चीज दीजिए जो हम रख लें, फिर उसमें नोटिंग करते हैं ना.
अभी कोई बात नहीं. इनका पेंसिल कटा के कोई दिक्कत नहीं.
चलिए, दिस इज WS ऑफ
WS of Dattas 1 to 5, 5 to 10.
इसको इसी में कहीं घुसाना है. वो जो आपको बंडल दिए थे कहाँ?
After WS of different number 3 उसके बाद. हाँ
उसको
इसके
बीच में ना
बाद. इसके बाद.
डलवा देंगे, ठीक है. ये दे दीजिए.
इसी के बाद लगवा.
इसको काट के दीजिए. अच्छा ठीक है. वाला नहीं है. अच्छा ठीक है, कर लेंगे। आप पढ़िए।
Lordship. That plaintiff had filed the present suit for a declaration that the plaintiffs have right, title and interest in Schedule A of the land. The defendants of the suit who are the purchasers from the present petitioners have no right, title and interest in. That from the plain reading of the pen, it will transpire the plaintiffs have claimed the Schedule A land situated in Moza Raguni originally belonged to Chandra Mohan Datta, Sambhunath Datta and Shashi Bala Datta, who were the predecessors of the present petitioners. Put later on, these predecessors of these petitioners, hereafter referred to as Dattas, mortgaged the part of their Jamandi interest in favor of the predecessors of their present plaintiffs, hereafter referred to as Pauls. The Dattas could not repay the loan. Pauls filed mortgage suit between 28 and 1941, and all those suits were decreed. In execution of these decrees, interest of the Dattas in the lands in question was purchased by the Pauls, and thus the Pauls derived the title in those lands of Moja Raguni, which earlier belonged to Dattas. After vesting of the Jamindari under Bihar Land Reforms Act, rents in respect of these lands were assessed under Section 567 of the BLR Act, and M forms 2 were issued in favor of the Pauls. Thus, the Pauls have derived right title and interest lands cured by the M falls and described in Schedule A of the pen, and continued to exercise diverse act of possession therein, including paying rent to the estate agent. That after the death of the predecessors, the present plaintiff continued to be in possession of the Schedule A land, and the manner their positions that is Pauls were doing, but from the newspaper publication dated such and such, the plaintiff came to learn that the defendants proposed to establish Sahara city homes, and the inquiry revealed that the defendants, through some illegal and collusive deeds, purported to have purchased Schedule A land, and hence the plaintiffs have been compelled to file a suit. The plaintiff very shrewdly suppressed the whole chapter of the matter in controversy by not disclosing those material facts which should show that the present petitioners have such substantial interest in the suit, and that without their presence, neither the suit can be disposed of, not effective degree can be passed in the present suit. That before enumerating these material facts showing the interest of the petitioners in the suit land, and it is essential to take note of certain parts of the plaint, specifically para 12 of the plaint, wherein it has been stated that Kailash Chandra Datta came sometime personally and sometime through collusive transfers and tried. STC failed to disturb possession of the proceeding were initiated, and all along they lost their efforts. The reality, however, is as follows. The Pauls never came in possession of the land belonged to the Dattas. All the mortgage suits decreed ex parte, as well as the execution cases, were void and collusive. Degrees never acted upon, and notwithstanding these documents, the Dattas, as well as their successors, including the present petitioners, continued to be in the possession of the scheduled land, as well as the lands of Moja. Furthermore, those degrees is not ascertainable as to which lands in respect of which mortgage degrees were passed, and the possessions pursuant to thereto were allegedly delivered to Pauls, which is indicative of the fact that the Pauls never derived right title and possession over the Schedule A land. It is true that the Pauls, in connivance of the Revenue Department, managed to get the rent assessed and M form issued in respect of the Schedule A land, and on the basis of those collusive and some degrees taking advantage of the fortuitous circumstances. Later on, the Dattas too applied for the assessment of rent under Section 567 of the BLR Act, registered as the rent assessment case number this and this. And in those proceedings, the Pauls too were impeded as parties, and after inquiry, it was held that the rents were wrongly assessed and the forms were wrongly issued in favor of the Pauls, and it was the Dattas in whose favor the rents and in respect of Schedule A land were assessed by the issuance of forms. Even since the rents in respect of the
Just a
schedule,
moment. Who passed this order? 81-82. This
Sir,
was
clause.
under. This was under BLR Act, or it was under remuneration laws?
it was under the rent fixation case, Lordship, under the BLR Act. 5,
Rent
6, and 7.
assessment case.
Yes.
This case number 1 Roman 3.
Lordship, it is
Of 81, 82.
actually some other number. 1 Roman 3 and 2 Roman 3.
Who is the who is the authority who has passed this order?
Circle officer.
Circle officer is entitled to pass an order.
That has been considered by the Deputy Commissioner.
Okay, we'll see this order.
Lordship.
Right? And next, continue.
Even since the rents in respect of Schedule A are being collected from the TAs and their successors, including the present petitioners, the names of the TAs have been duly entered in or registered to, and since 80s, the rents have not been collected from the polls, including the present tenants. Aforesaid vital facts and relating to the issuance of M form and collection of the rents from the TAs, including the present petitioners, on from 1983 have been conveniently suppressed by the plaintiff so as to ensure that they are not compelled to make the TAS, that is the present petitioners, parties in the present suit. The fact that the TAS, including the present petitioners, have been in possession of Schedule A land as well as other lands in also established from the facts that between 1964-2003 the TAS have transferred various portions of Schedule A land by registered sale deed to various purchasers. The details which are given here, all these purchasers are possessing their respective purchase portions by exercising diverse act of possession like constructing house, making construction, getting their names mutated, etc. The details of the land of Schedule A sold by the family of the TAS. These are the...
They are also parties before us?
No.
Done. Is there any suit for cancellation of this deed?
They have filed a lordship. Any exercise done by the TAS in contravention of the auction cases, it will not be legal and valid. That is only the prejudice. No cancellation for sale deed.
No cancellation of sale deed as such. Right?
No such.
The challenge is to the very root of the title
Yes.
of the case, where these persons party at any point of time.
Never, they were never. Even the TAS were not made party. What to talk about?
No, that's it. That does were not made party.
Even these persons.
These persons,
Not.
neither these persons are made party, nor their sale deed is under challenge.
Yes.
And they are in physical possession.
Physical position, mutation is there. Everything is there.
So subsequently, suppose these dattas, suppose dattas lose the case, right? Then at the time of execution, they will have their independent objection.
Yes. They will have.
They will have their own rights.
Because we were not party, it is not binding upon us.
It is not binding, limitation, and so many things.
Order
because
21,
they are already
96,
having knowledge of these deeds,
Yes.
that they are in possession.
Yes.
Recovery will be another issue.
Another issue, Lordship.
That is a separate thing, but still.
But Lordship has
We are
rightly
just,
pointed out.
you see, because there are so many persons who are in possession.
Yes.
So I just want
Many, they all know about. And what happens, Lordship, in these kind of cases, Order 21, Rule 97, 98 applications are being filed. They are treated like a suit, and again a suit will go.
That is a separate thing. We
Yes,
will just
yes,
decide
but-
the right of dattas
Yes.
and right of Pauls.
Yes.
This is what is to be decided.
Yes.
Then how is Sahara coming into picture?
They are the purchasers from the TAS.
They are purchasers from dattas. Yes. And Saharas are purchasers
Ultimately
from
not-
dattas. And how is the Sehkari Samiti coming into this?
I said it is a part of the TAS. Lordship, I'll explain. For some पता कर लेते हैं क्या है. Sahara का ही part है. 1, 2, 3 all are part and parcel of Sahara. And it was purchased in the name of defend number 3. The Sarkari Sarkan Samiti is there, that is the part of parcel of Sahara. वही दत्ता से वही खरीदा as per the documents.
सेल डीड होगा ना एग्जिबिटेड.
हाँ.
उनका सेल डीड
हाँ,
एग्जिबिटेड
पूरा
होगा.
exhibited.
कौन कैसे खरीद रहा है
सब
और
सब
कैसे वो प्रॉपर्टी जो है सहकारी का समिति के पास जा रहा
नहीं,
है
सर.
और कैसे उनका म्यूटेशन हो रहा है. You see, this cooperative society, you just kindly consider
Yes,
this.
yes, I
This
got what
cooperative
you're
society is represented. Cooperative society is consisting of the purchasers of the property.
Yes.
ठीक है. अभी वो प्रॉक्सी वॉर लड़ रहे हैं through the cooperative society. Right? कोऑपरेटिव सोसाइटी उन्हीं लोगों का ना होगा जो लोग वहाँ रेजिडेंट्स होंगे.
जो है जो कोऑपरेटिव के मेंबर है उन्हीं
जो
का.
कोऑपरेटिव के मेंबर है उन्हीं का है.
Yes.
जिनका वहाँ प्रॉपर्टी है उन्हीं का है. जिनके नाम से सेल डीड एग्जीक्यूट किया है दत्तास ने उन्हीं का है. Right?
उसको हम थोड़ा
अभी प्रॉक्सी वॉर चल रहा है.
examine कर लेंगे उसको because several I think 15 to 20 seal deeds have been exhibited by us.
ठीक है, आगे रोमन 9 पर.
Was also been suppressed in the print is that the present plaintiffs filed title suit number 26 of 2003 against the present petitioners for declaration of title and injunction in respect of the plot number 428, area 75 decibels. This they have stated lordship that this ended in a compromise under khata number 66 about 5 lordship. On the same ground that their predecessors got this said land through aforementioned mortgage suit, M forms, etc. In the said suit, the present plaintiffs paid temporary injunction, but learned court of Munsif second dismissed the said injunction petition, holding that the present plaintiffs, that is Pauls, have never been in possession of the said plot. Rather, it was the task, including the present petitioners, who have been in possession of the said plot. The said injunction attained finality, which is a strong circumstance to show that the task, including the present petitioners, have all along been in possession of all those lands and allegedly which acquired by Pauls through collusive suits. This order was never challenged. Ultimately, lordship, the suit was ended in a compromise. It has also been filing the present suit. The present plaintiff filed a revenue miscellaneous case number such and such before additional collector Dhanbad against the present petitioners in respect of Schedule A land, seeking cancellation of Jawabandi of the TAS, including the present petitioners in respect of Schedule A land, and on the ground that the rents had wrongly been assessed and the M forms had wrongly been issued in favor of the TAS in early 80s. From that revenue case, it is apparent that the present plaintiffs admitted that the TAS occupancy raises in 83 pursuant to the rent assessment case number 1 of 82 such and such, and the names of the TAS have been showing in Jawabandi since 1980s. In fact, that the said miscellaneous case number 54 of 2005 was finally heard and decided by London Deputy Commissioner Dhanbad, and by an interim order dated 10/2/2009, London Deputy Commissioner held that M forms were issued in favor of the TAS by Circle Officer Bagmara, who did not have the jurisdiction. This is what Lordship was seeking: jurisdiction to pass such order, but in the same order, it was held that the M form issued in favor of Pauls were also alleged. The defendants in the present suit filed a writ application before the Honorable High Court against said order dated 10/2009, passed by Deputy Commissioner on the ground that Circle Officer had jurisdiction to issue M forms, and the said writ application is still pending.
ये कौन सा petition?
The task explain करेंगे उसको पूरा.
Yes, Dattas. Who is representing Dattas? बिल मतलब क्या? आपका रिटन स्टेटमेंट है. पूछिए, आपके क्लाइंट लोग पीछे बैठे होंगे. इसमें रिट का नंबर क्या है?
If I remember it correctly, it was withdrawn before your lordship in old court number 7. I'll just check it and I'll
Number है ना?
because there are so many petitions I'm absolutely
जरूर विड्रॉ.
I've written in my notes itself.
देखिए, जहाँ कोई रिट आता है, where any related suit is pending, हम तो उसको entertain नहीं करते, because there are so many nuances to a suit. और रिट में एक ऑर्डर हो जाने के बाद बहुत दिक्कत. चलिए आगे. इसका भाई थोड़ा बताएंगे. Silence is not a solution. Silence will speak volumes against you. चलिए आगे बढ़िए.
Yes.
Furthermore,
Yes, Lordship. Furthermore, the TAS submitted return in respect of suit land and other lands and received compensation. During recent revisional survey, name of the TAS and their transfers have been recorded in revisional survey record of right, which itself established right title interest and position of the present petitioners over the suit land. That from the above facts and circumstances, it is apparent that the present petitioners have substantial interest in the suit land, and so much so that without the presence of the real issue relating to the title cannot be decided, because the title have been claimed on the basis of the above mentioned collusive suits and fraudulent forms. In those matters and the issues have been decided between the Pauls and the TAS, that the present petitioners are the best competent persons to answer those questions which will decide the issue of the title involved in the present suit. If the real issue involved in the present suit to and between the Taz and Pauls is also evident to the fact that the present plaintiff 1D filed a complaint case being CP case number such and such before Dhanbad, CGM Dhanbad against the present petitioners and their transfers alleging forgery etc. But the substantum of the said complaint is again the same issue of title between the Taz and Pauls. Plain reading of the complaint petition will reveal that it is the exact reply of the plaintiff filed in the present.
Okay, we have seen it. Defendant number 3 filed the written statement. Defendant number 1 and 2 did not file the written statement.
Did not.
Correct?
They are not.
They are the persons who had formed this cooperative society.
Yes. And they have given the paper publication which is the cause of action.
Who had given the paper? अच्छा, paper publication
Paper में
for
निकाले थे
construction
वो.
of building. दो चीज है ना, एक होता है कि प्रॉपर्टी है कोऑपरेटिव सोसाइटी की, पेपर पब्लिकेशन एक पर्टिकुलर कंपनी निकाल रही है कि हम यहाँ कंस्ट्रक्शन करेंगे एंड दे हैव अ क्या बोलते हैं उसको
डेवलपमेंट
एग्रीमेंट विद द कोऑपरेटिव
हम
सोसाइटी,
इसको थोड़ा देख लेते हैं, उसको एनालाइज करते हैं.
क्योंकि ये बहुत सस्पिशियस है
बहुत
कि डिफेंडेंट नंबर 1 एंड 2 है लेकिन रिटन स्टेटमेंट नहीं फाइल किया.
नहीं.
उन्होंने अपना स्टेटस नहीं बताया है कि उनका वो क्यों यहाँ पे पार्टी कर रहे हैं.
ये पार्टी तो यही लोग बनाए.
ने पार्टी बनाए हैं लेकिन रिटन स्टेटमेंट नहीं फाइल कर रहे, इसका क्या
Yeah,
मतलब
I
है? What
think
is
we have-
who is representing Sahara? Who is representing Sahara?
हम ही लोग कर रहे हैं. 1 2 3 सबकी तरफ से.
वकालतनामा फाइल किए हैं कि नहीं?
Only one thing I'll point out.
We are the applicants.
Defendant number 3 is written statement, Your Lordship.
They have
They have stated
statement
that
is
as
there.
regards the 1 and 2, they
Have
are
no
absolutely unnecessary.
Yes, we have
This-
stated.
Okay. तो आप जो अपील फाइल किए हैं 1 एंड 2 को तो कोई मतलब नहीं है, तो 1 एंड 2 की तरफ से भी
अपील
फाइल
नहीं
करते
होना
हैं ना?
चाहिए था, 3 की तरफ से होना चाहिए.
हाँ भाई, आप you will distance yourself as per your sweet will.
And that is true. That is true.
तो 1 एंड 2 की तरफ से तो यार ऑलरेडी नॉन सूटेड, आपको क्या करना है बताइए. 3 has no concern with 1 and 2. उसने एक ढाल दे दिया 1 and 2.
हाँ, ये तो अपने WS में लिखा हुआ है, तो हम इसे कैसे करें? हम
इससे
शुरू में ही
कैसे-
लिखे हैं, जो नॉन जॉइंटर मिस जॉइंटर का लिखे हैं, तो उसमें लिखे हैं पैराग्राफ 2 में 3 कि they are not a necessary party, they should not have been implicated as party. Only because the paper publication was done by them that this is the land we are going to develop as Sahara city.
Why have the come? जरूर को होगा डेवलपमेंट एग्रीमेंट.
हाँ, कुछ तो होना चाहिए. Otherwise, advice should not have been there to file an appeal against.
एडवाइस उनको कौन एडवाइस देगा?
नहीं,
कंपनीज
जो-
को एडवाइस नहीं, उनके अपने एडवाइजर.
हाँ.
They are
Yes.
not to be advised.
Lordship is correct.
You see, companies
उनके
they are
अपने-
not to. They have their own system.
Own it.
और बिना काम के तो वो अपना 98 भी खर्चा नहीं
नहीं, क्यों कर सकते हैं?
कोई भी कंपनी फॉर दैट मैटर,
Yes, yes.
राइट. रूटीन अपील नहीं फाइल करते,
रूटीन अपील तो फाइल करेंगे.
नहीं करते हैं. जब कोई मतलब नहीं है तो इस अपील को कैसे फाइल किए आप, उनकी तरफ से भी या आपको भी समझाना
हाँ.
होगा. ठीक, देखिए बहुत ज्यादा मैटर नहीं,
बिल्कुल.
मैटर सिर्फ इतना है कि दत्तास का क्या स्टेटस है
Yes.
एंड वेदर व्हाट इज द कॉन्सिक्वेंस ऑफ दैट ऑप्शन.
पॉल क्या डिराइव किया और दत्ता का क्या स्टेटस रह गया उसका?
You are representing Dattas. Your case is that you were the recorded tenant. No. Your specific case is that you were the recorded tenant, and you continued in possession of the property, and therefore, by virtue of vesting, you became the tenant of the state. So rent assessment will not give you title. Right?
Further confirmation of
Confirmation.
title, right, interest,
और बताइए.
अब इसको WS खत्म हो गया, तो 10 मिनट हो गया, इसको हम लोग फिर शुरू करेंगे वहाँ से. एग्जिबिट साइल एक्सप्लेन, बस हम भी अच्छे साइल देख लेते हैं. tomorrow I'll be in a better place.
देखिए, आपको 2:15 बजे का टाइम दिया है, तो 4:30 बजे तक तो आपको बहस
करें.
करना होगा. ठीक है, चलिए.
One writ petition number, Your Lordship.
Mr. Sharma is there here? एक केस में हमको ऑर्डर नहीं आए हैं ना. कल 10:30 बजे फर्स्ट केस वो रहे जाना. हाँ, उसको tomorrow कर. एक ना आधा डिक्टेशन दिया, तो केस हियरिंग में चला गया है, वो फाइनल डिस्पोजल में नहीं है। हाँ बताइए।
एक रीट का नंबर लिखा
हाँ बताइए नंबर।
Your Lordship, रीट WPC number 2586 of 2009.
2586 इसका प्रिंट निकालिए।
But Your Lordship, details I'll take it out because in
अभी-
my notes I have
कोई बात
mentioned
नहीं,
this.
इसका रिकॉर्ड समन करिए इसका। WPC नंबर 2589 of 2009।
2586 of 2009.
2586 of 2009। Date of disposal
29/3/2023.
इसका ऑर्डर निकालिए थे, अपलोडेड हो गया। हाँ बताइए उसके बाद क्या हुआ, किसकी तरफ से कितने विटनेस आए। अब इतना सुनने के बाद, प्लेन रिटन स्टेटमेंट देखने के बाद एक बार इम्प्यून जजमेंट देखना चाहिए।
हाँ
क्या इश्यूज फ्रेम हुआ,
ट्रायल कोर्ट का
ट्रायल उससे काफी क्लियर हो जाएगा।
यस एंड उसके बाद हम चाहेंगे ट्रायल कोर्ट का जजमेंट से बेटर होगा कि हम लोग अपडेट कोर्ट का जजमेंट देख लें, ज्यादा क्लियरिटी है उसमें,
ठीक है, कोई बात नहीं।
क्योंकि वो दैट इज कंफर्मिंग द जजमेंट ऑफ द ट्रायल इश्यूज लॉर्डशिप। मैं पास ऑन वन कॉपी
इसका
इशू का अगर फोटो कॉपी में इशू का अलग से लिखा बना
अच्छा दे
हमको ही पढ़ना हो तो एक कॉपी
इशू तो ट्रायल कोर्ट के जजमेंट में होगा।
हाँ जब लेकिन इट्स बेटर होगा। अरे हो ठीक
अब समझ गया कि ट्रायल कोर्ट का जजमेंट क्यों नहीं पढ़ना चाहते।
आई नॉट से मच
हिंदी में आप पढ़ना नहीं चाहते।
और हिंदी में जो टाइप कॉपी है पढ़ डिफिकल्ट हो रहा है थोड़ा पढ़ना।
तो चलिए पढ़िए, इश्यूज पढ़िए।
लॉर्डशिप
On which all issues will be delivered.
लॉर्डशिप 5 6 into 8 is there any cause of action?
Just a moment. कोई इंस्ट्रक्शन नहीं है। Dismiss as not pressed. Read petition 2586.
Super important.
चलिए पढ़िए।
Is there any cause of action for the suit? Is the suit as framed maintainable? Is the suit barred for non-jointer and misjointer of parties? Is the suit barred by limitation? Is the suit barred under section 34 of the Specific Relief Act? Is the suit grossly undervalued? Where the plaintiff are entitled to the relief of the declaration of their right, title and possession over the Schedule A lands? Where the plaintiffs are entitled to the relief of the declaration of the dependents have acquired no right, title and interest in Schedule A lands of claim by virtue of their spurious purchases, whether the plaintiff are entitled to a decree declaring the transfer, sale deed in respect of the Schedule A lands or any portion thereof by the judgment debtors of the execution case number this and this, that is Chandra Mohan Datta, Shamunath Datta and Shashibala Dasi, or their successor interest is null and void, that the plaintiffs entitled to the reliefs claimed in the suit, or to what other relief or reliefs the plaintiff are entitled to.
Section 34 is important.
Yes, Lordship. That I wanted to say in between also.
So
Since
you
Lordship
have,
there,
you see 1, 2, 3 and 4. Limitation is also important. Not important. So 1, 2, 3 and 4 we can forget.
yes, Lordship.
You have 6 also we can forget. Correct?
Yes.
10 and 11 also we can forget.
7, 8, 9.
We are with 5,
7, 8, 9.
8 and 9. Okay. This would be the point of determination here also.
Yes.
Yes, is that correct? Issue number 5, 7, 8 and 9 would be the point of determination. एक बार check करिए।
5, 7.
Yes.
ठीक है, बाकी सब irrelevant है।
हाँ.
इसको थोड़ा नोट करेंगे, है ना? इशू नंबर 5, 7, 8 and 9 इसी को पॉइंट ऑफ डिटरमिनेशन बनाना है। आगे बताइए।
अब जो अपडेट कोर्ट के पैराग्राफ 25 के इश्यूज वहाँ पे भी है, पेज 13 ऑफ द अपडेट। page 30.
एपिलेट कोर्ट ने अपील डिसमिस किया था, पहले अपील अलाउ किया था कि डिसमिस
Dismiss. Confirming the order of the trial.
चलिए पढ़िए कहाँ से पढ़ना है?
हाँ, para 25 से. Issues दिया है para 25. What you got that? Thereafter para 26. On the basis of the oral and documentary evidence, the learned trial court recorded the finding of the fact with respect to the main issue 7 to 10. इसमें 10 भी कह रहे हैं, ठीक है, 10 is relief. In favor of the plaintiff, and other issues have also been decided in favor of the plaintiffs, and the suit has been declared. The appellant number 1 and 2 are Sahara, and the regional manager of Sahara India Commercial Corporation. Appellant number 3 is the contesting defendant. Number 3, Karmyogi Grih Nirman Swarna Samiti. Appellant number 1 and 2 have appeared before the court below, but had not filed their attestation. Challenge to the judgment of the decree follows on the ground that the said court auction, sale, and the consequent delivery of possession comprising of the several plots of the land in a single day was not as per the procedure laid down under the Code of Civil Procedure, specifically under Order 21 Rules 72 bracket A, Rule 89 to 82 and 99, specifically, especially Rule 85 and 94 of the Order 21. The said order.
Just a moment. This is not the case.
इसको skip कर लेते हैं 28.
नहीं देखिए ऐसे नहीं आ पाएंगे, ऐसे हम नहीं पढ़ सकते. This is not the case that the procedure was not followed. So far as option.
No, nowhere it has been mentioned.
It is not the case.
Not even. We have only said that it was an ex parte.
Ex parte होने से क्या हुआ? ये तो केस ही नहीं है कि ये प्रोसीजर नहीं फॉलो हुआ, फ्रॉड हो गया.
It might be from the arguments made by the parties that has been considered. Only that has been stated. Therefore, Lordship, हम उसको अभी नहीं कर रहे हैं.
ये पैरा 29 पर.
Para 20.
और एक बात ये वाला नेक्स्ट पैराग्राफ पढ़िए, बट वी विल टेक ऑल दीस थिंग्स विद द पिंच ऑफ सॉल्ट, राइट?
Yes.
इसका नहीं
That person behalf the appellant submits that trial court ought to have considered.
ये रिमाइंड हो क्या है ना पहले प्रीवियस जजमेंट पे. हाँ बताइए. पढ़िए.
Not to have considered the bar under section 35 of the BRR Act and accepted the entries of the revenue demand register as they stood since 1982. The learned court below failed to formulate an issue for determination of possession of parties. The learned court below also failed to appreciate the non-jointer of necessary party by the plaintiff went to the root of the matter. After the order passed in 1982, the inaction on the part of the plaintiff amounted to waiver, acquiescence, and estoppel. PW1 has specifically stated that they were in possession of the suit land. Not in possession of the suit land. From the pleadings of the parties following admitted possession emerge as these facts have not been specifically denied. Suit land originally belonged to and was in possession of Chandra Mohan Datta, Shambhunath Datta, and Shashi Bala Das. Chandra Mohan Datta took loan by mortgaging his 2 ANA interest in the said Mauja from Murlidhar Paul, leading to mortgage suit number 61 of 1928 against Chandra Mohan Datta, which was decreed on 23/11/1929, and the said decree was put to execution in execution case number 492 of 1935, and the property was auctioned. The entire mortgage debt was not satisfied, and therefore Murlidhar Paul and Haribol Paul filed execution case number 14438, and the entire interest in Shashibala Devi inherited, that is Kevat number such and such, and her interest in Ijmal Kevat such and such, and 77 of Mauja Rogini was sold, and sale certificate 18/3/1939 was granted.
These sale certificates are on record.
Yes.
आगे बढ़िए.
Para 12 of WSD3. Execution case number 138 of 1940 was filed against Surendranath Datta for realization of the rest of the decretal dues and was allowed. Murlidhar Paul and Haribol Paul filed title suit number 8 of 1941 under Order 21, Rule 63 CPC in the Court of Subject, which was decreed on 1999. These are all admitted facts, also been exhibited. Murlidhar Paul and his brother filed mortgage suit number 23 of 1930 against Shambhunath Datta, which was decreed, and his as interest in Khewat number such and such was auction sold and purchased by the decree holders in execution case number 140. In F Lordship, I have objection. F. After vesting of the intermediary interest under Bihar Land Reforms Act 1950 on 1/156, M forms were issued in the name of plaintiff. Issuance of M forms is admitted in para 17 of WS of D3, but contended that issuance of M forms was by collusion with revenue authorities. These M
Did you
forms.
admit it?
Lordship,
Did you admit issuance of form?
we have said that it was with collusion of the revenue authorities. But later on, Lordship, in the IA which we have preferred for the additional evidence, that we have got a document from the circle officer, who is the custodian of the record, says that all these M forms does not find place in our and out of 5 M forms, only 3 M forms were filed as certified copies. 2 M forms, Lordship, cannot be considered even by the court. Even the IA is not considered because those 2 M forms are only the photocopies. The point of the dispute is about possession pursuant to the auction purchase in the mortgage suit and execution case. It is contended on behalf of the defendants that all the mortgage suit were decreed ex parte, were void and collusive decrees, and the execution cases were never acted upon. And notwithstanding these documents, the Tattas as well as their successors, including their present petitioners, continued to be in possession of the scheduled land as well as the other lands of Moja Ranguni. Before proceeding further, it will be appropriate to consider the case of now, Lordship. These they have been deleted.
The point of dispute will be the status of Dattas as Rayyat or not. I think that would be the point of dispute,
Yes.
not actual physical possession. We'll see that what is the consequence, who is in physical possession. But when the landlords they mortgage their property, then under such circumstances, do they divest the tenants of the property?
Tenancy of
Tenancy of the
yes, yes. Now this is the question. In the mortgage, whether they
And-
divest of the tenancy of the property which they acquire as their own property.
And upon vesting, even if the mortgage property is sold, it is sold with, and this would be your case,
Yes,
subject to
this
what
is-
they have to say. It is sold with tenancy, and therefore upon vesting, the tenancy would be, the tenancy would vest with the landlord will be the superior landlord. Whosoever is the landlord
Yes.
is immaterial.
It's immaterial.
चलिए 4:30 बज गए.
There had been cases, Lordship. Now, if I am the landlord, and now my property is being auction purchased by the other landlord. Now I become a tenant under his landlordship.
देखिए ये सब इश्यूज बैंक ऑक्शन में सब डिसाइडेड है. अब आप इस ऑक्शन को उस ऑक्शन से कैसे कंपेयर करते हैं, कंपेयर कर भी सकते हैं कि नहीं करते हैं, आई डू नॉट नो, बट दीज इश्यूज हैव ऑलरेडी बीन डिसाइडेड इन बैंक ऑक्शन इन न्यूमरस केसेस.
Lordship is
एक नहीं कई केसेस में इस तरह की इश्यूज डिसाइड हो चुके हैं. आई डू नॉट नो वेदर यू विल डिराइव एनी बेनिफिट आउट ऑफ दैट. वो अलग ही तरह का ऑप्शन
हाँ.
होता है, स्पेशल लॉ में ऑप्शन होता है, वो सारी चीजें अलग है. लेकिन ऑप्शन की प्रक्रिया सो फार एज सीपीसी इज कंसर्न्ड इज प्राइमरी एप्लीकेबल ऑन डीआरटी ऑप्शंस नहीं.
उसका अलग बना हुआ है. यहाँ CPC से गाइड.
नहीं वहाँ पे सीपीसी से गाइड
But वहाँ पे अलग लॉ के बना हुआ है. This is how
थोड़ा थोड़ा काफी कुछ इनकम टैक्स
Income tax note second schedule,
आप देखिएगा तो पैरेलल ही है.
Rule 11 and Rule 17.
एनीवेज चलिए अभी तो
33 में इसका point for determination was framed by the
वो हम सब दिखा देंगे ना.
वही
हाँ.
same more or less your lordship, only one that would not be there, which was again the state's
वो
portion.
उस पे हम लोग आएंगे. उस पे आएंगे. इसको हम आगे कंटिन्यू करेंगे.
चलिए
Tomorrow at 2:15.
हाँ for that part as the court time is over, post this case for further hearing tomorrow at 2:15. आप लोग सब अपना अपना appearance memo दे दीजिए. ये नीचे जरा इसको टाइप कर लेंगे. इसको 10 भी रखते हैं इसमें 10 भी रखना जरूरी है क्योंकि ऑलरेडी प्रॉपर्टी इज इन पोजीशन ऑफ थर्ड पार्टी, तो इशू नंबर 10 है व्हाट
हाँ
रिलीफ
ठीक है।
दैट शुड बी देयर।
और भी कुछ पॉइंट ऑफ डिटरमिनेशन जो अपलेट कोर्ट बनाए हैं हुजूर उसको भी देख लें।
हाँ देखिए,
और हुजूर उसको मंडे को ही रखा जाए, कल थोड़ा सा डिस्टर्बेंस है।
हमको कोई डिस्टर्बेंस नहीं,
ठीक।
आप लोग आइए, ऑनलाइन भी ज्वाइन